This is Wes Porter, professor talking about criminal law and essentially an intro to what would be a course on criminal law. Some of the things we want to talk about, some of the things I want you to have on your mind as you enter into your studies of criminal law. This is the basic framework from which we're going to have our learning kind of shaped. And the first one has to do with, it's all about statutes. Nothing happens in criminal law in the modern day without an applicable statute. We land on the model penal code because that's something that we came up with, model penal code that's been adopted by certain states, adopted in part by other states. Essentially, it's a good representative of black letter restatement of what would be criminal law. Same thing, we'll explore some other statutes, some applicable statutes, maybe something that's interesting or different, maybe something that's typical in some states, but we always start with a statute. And that we don't describe criminal law as this is a statutory analysis class, but it really is, and it's a good course to start working with statutes and understanding the different parts of crime that we're going to talk about. As we get to the case book, really it's important when you're reading a case. I think this is in any course, but particularly criminal law. What part of the course does this fit in? And essentially, what did the author, did the case book itself, what does it hope that this case contributes to your understanding, to your learning? So each case should fit somewhere in your outline. It should fit somewhere to contribute to your understanding of what could help you solve a future problem. And that leads us into the last thing, which I think is the most important: confronting the next challenge, confronting the next problem in criminal law. We'll talk a little bit about the different orientations between what happens in a case book and what happens in your future problem. But essentially, you're going to get presented with facts of what did some defendant wake up in the morning and do, and against a statute, what could we charge, what will we charge, or essentially how would you find as the trier of fact, the jury or judge in the judge alone trial. Okay, so here's a little bit of what we'll see. The appellate case context, that's most of the cases that are going to be in our case books. That's most of the cases in every law case book. Not a lot of things come from the trial court. And essentially, in criminal law, you have to think about it under the understanding that this is a case that was charged, indicted. This defendant went to trial. This defendant most likely lost that trial. And now, because it lands as an appellate opinion, now is challenging that conviction at the appellate level. Primarily two ways that they're going to challenge. There's lots of ways, but primarily two ways that you're going to find in your case book. One, they're going to say, hey, the lower court, the trial court, got the law wrong. And maybe because it was unsettled at the time, or maybe because the court was sloppy in some way in instructing on the applicable law, and that's what they're having the appellate court review. The good things to understand and how it might contribute to our understanding is a review in court saying, no, the law must go this way and not the way that this lower court instructed. The other one, so that has a little bit of a chance. Essentially, it could be reversed and remanded back to that trial court to say, give them the right instruction and see if a different jury comes back with a different result, hopefully for the criminal defendant, a not guilty instead of a guilty like in the first one. The second one, less helpful, bearing less fruit, is the evidence against the defendant was insufficient as a matter of law. And just think for a second about what we're really asking of that appellate court. The prosecution brought a case, tried a case. It was found, the defendant was found guilty unanimously by that jury. But after the verdict, we're going to appeal. The defendant was sentenced. After the judgment and everything that happened at the trial court, we're going to take it to an appellate court and say, even though a jury found unanimously that the defendant was guilty, really the evidence was insufficient. So you can see it's a tough road to hoe. And this is the posture from which we are reading these appellate cases, which sometimes can get confusing, especially early on in law school. Let's juxtapose that with your next problem, your next challenge, your exam, your bar questions. Okay, here's the class context or the exam context. Most of the problems we'll get, it's essentially, it starts out the same way with a facts section. What did some defendant wake up in the morning and do? Except now, we have to pay attention to the call of the question. As a prosecutor, what can you charge? They might give you some statutes to choose from, or a statutory scheme to choose from, and say, of these different available charges, what would you charge? It might rely on, we still have to memorize, as you'll see, some parts of the common law, because that's what the bar tests. So it might be like, without a statute, just a jurisdiction that follows common law, fictional jurisdiction that follows common law. What would you charge, or what are the best facts, or what would you argue in support of those charges? The same thing from the defense side. We're going to talk in this course about some of the defenses that are applicable, and what could they argue? And then ultimately it might be, hey, this is charged. Hey, this defense was raised. As the trier of fact, that is the jury or judge in a judge alone context, what would you decide? Understanding the burden of beyond a reasonable doubt. So it's different from the cases that we'll read that are really reviewing a conviction that already happened. Now we're laying facts out and we're saying, what would you charge? What would your defense be? Now, here's essentially an outline of the course, very broad, very big picture, but it at least allows you to orient yourself as to what we might be talking about. Now, especially in the beginning, but throughout the course, really, we'll introduce parts of the criminal process, what happens at different points. Here, it's important to footnote, there are courses that sound similar. An undergraduate, you might have a criminal justice course that could cover any number of things. We're in a criminal law course, or sometimes different names at different law schools, which really has to do with what we're talking about here: crimes, parts of crimes, defenses, that type of thing. There's also criminal procedure, and some schools have criminal procedure broken down into 1, 2, maybe even more parts. So as it relates to criminal procedure, we're really talking about the investigation side, talking about the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, searches, statements taken from defendants, how you're gathering up evidence. That's not criminal law. Criminal law, we're accepting the evidence as it is. This is the evidence. This is what not only the defendant woke up in the morning and did, but this is the state of the evidence. This is what we have as we're confronted with deciding whether to go to trial or deciding whether to charge as a prosecutor. So we'll talk a little bit about where we are in the criminal process. We'll talk a little bit about sentencing, which follows a trial in the criminal process. We'll talk a little bit about some of the justifications for sentencing and so on. But we'll spend the most time, really in these 2, 3, and 4, the parts of crimes, and defenses. So let's talk about that a little bit. Here's our a couple of parts of crimes, and we're going to spend some time in our first, opening classes together, really talking about this. Every crime, most crimes have an act, an actual physical thing, a willed muscular movement that we must do. We must compel ourselves to act. And sometimes it's conduct that is prescribed by the statute, set forth in the statute. Thou shalt not take, thou shalt not hit, thou shalt not strike, whatever it is, that's the actus. That's the act that is prohibited. And it's connected in this way where you can't do this thing, you can't act in this way with this requisite intent, this what's going on in our brain at the time. The combination and really alignment of the prohibited act with the right type of intent, and sometimes there's lots of intents that may qualify, that brings about this social harm, the reason they came up with the statute. Almost every statute that we talk about, and we talk a lot about the funny statutes that are around the country and different things that are prescribed by different jurisdictions, but really it starts out with what's some evil, what's some social harm that we're looking to reduce, that we're looking to do away with, and we want to punish, and we want people not to do it, we want them to be on notice and not to do it. So we sort of described the act and the mental state that causes that social harm, and then of course E has to do with some of the applicable defenses, justification defenses or excuse defenses. Some of the crimes that we'll talk about, we really don't go through a ton of crimes because again, we're studying the common law. So we're going to talk about those parts of crimes, but we're going to talk about murder primarily. We're going to handle some property crimes, crimes against the person as they're called. And we're going to talk about what's called inchoate crimes. Those are the crimes that are attempt and conspiracy and solicitation, sort of, the attendant crimes, the crimes that can be charged when we're on the pathway to committing a crime. We're going to talk about specific defenses, excuse defenses like insanity, justification defenses. I may have acted in that way with the requisite intent, but I was justified in doing so, like self-defense or defense of others. And we're going to learn about a number of other defenses, including that the government didn't prove their case. That's a popular defense that you might just argue the burden and argue the elements. You could argue mistake of fact. You could argue voluntary intoxication, a number of different defenses. And there you see some of this is kind of the crimes as they break down by category. The most popular one that we'll cover against the person is going to be murder and all the variations of murder and how different statutes and jurisdictions address murder. We'll again talk about property, larceny, burglary, robbery being the big ones. Inchoate, I already talked about inchoate offenses, attempt offenses, conspiracy, solicitation. In addition to that, accomplice crime, when you have more than one person that's involved in their different roles as principal or accomplice. And then there's a category out there that we don't spend much time at all, but of course keeps our courts very busy, which is crimes against society, namely drugs, guns, other ills that are in our society that we spend a lot of time trying to address with our judicial system.